Peace and love and prosperity to the human family. Today, AMPAG Moxon will be discussing a very important topic, something that a lot of Moors are wondering what it is. And that question is, what is international law? How is it applied? And where is the benefits? Why do we need it? So we'll be covering a few a few items dealing with this particular subject matter. Hopefully we all learned something. And if anyone has any questions, concerns, as I've already stated before, you may butt in and ask your questions. But let's be mindful of the time. Let's not be like the good brother Floyd doing. Let's not take over the conversation. Let's consider others. Okay. And he hadn't showed up. In fact, I forgot to send him the link. It's fine. I'll send him a link on the next one. It's too late at this point, I suppose. So without further ado, let's get right into it. I'm gonna share my screen. Let's see. Okay, let's go straight to the rights of indigenous peoples. Let's understand the rights of indigenous people a little better than we currently do. So it says here, the United Nations Declaration on the Rights of Indigenous Peoples was adopted by the General Assembly on the 13th of September 2007. By issuing the declaration in this pocket-sized format, the Office of the United Nations High Commissioner for Human Rights, it's all about human rights, just cogents, wishes to make these important new human rights standards available to government officials, human rights defenders, indigenous peoples, i.e. Moors, scholars, legal practitioners, civil society, and others wanting to promote the rights of these peoples worldwide. And of course, we want to promote the rights of these peoples worldwide because these people are us. Okay. So as you see here, it is the United Nations Declaration on the Rights of Indigenous People, and we're not going to go through the entire thing. We're definitely going to go through the preamble and a few of the articles just to make the point clear without dragging out the time. But at some point, we'll go in further details with this particular document. So the preamble goes: the General Assembly, guided by the purposes and principles of the Charter of the United Nations, in good faith in the fulfillment of the obligations assumed by states in accordance with the Charter. And we'll see that they continuously keep talking about states. And if I were to ask Black people, Moors, those who call themselves Aboriginal, Indigenous, African Americans, Moorish Americans, NBCs, whatever you may, Cherokee, Indian, what is the one thing that we don't have? What is the one thing that we haven't had? We went through the 60s, getting hung and lynched and all these atrocities. States. We don't have our own state. We don't have our own country. For some reason, we tend to think that the temple is a state, but it's, if you were to examine Act 5 starts off by saying this organization. It's not a state, it's an organization. That was teaching us the divine aspect of ourselves to get us prepared for the national side of the movement, i.e. divine and national movement. But the divine side dealt with teaching us who we were and who we are, not were, but who we are. Because how can you competently operate a state government without knowing who you are as a people? So obviously the divine side had to come first, which is the understanding as to who we are as a people and the authority that we have under the sovereignty, the pre-existing and existing sovereignty of the Empire of Morocco. As I continue, affirming that indigenous peoples are equal to all other peoples, while recognizing the right of all peoples to be different, to consider themselves different, and to be respected as such. affirming also that all peoples contribute to the diversity and richness of civilizations and cultures, which constitute the common heritage of humankind. So, it says that peoples, affirming also that all peoples contribute to the diversity and richness of civilizations and cultures. Well, that's a contribution that we gave the world since time immemorial, right? For the most part, you can really identify yourself in this document if you were to read it from your perspective as one of the peoples, or more specifically, indigenous peoples, right? Because who are the indigenous peoples of the world? Moors, the Asiatics, those who are melanated. Affirming also that all peoples contribute, I already read that. Affirming further that all doctrines, policies, and practices based on or advocating superiority of peoples. Okay, what that sound like? United States, so-called white supremacy, which is an illusion, by the way. And not only is an illusion, but it's a falsehood. There's going to be a lot of PO'd Americans, foreign Americans, or I guess white people, when they find out the truth, because there's a false sense of superiority within their culture, and there's a false sense of inferiority within our culture, when in actuality it's flip-flop, right? But it doesn't necessarily mean that we're just, I'm not saying that we're superior to people, but we do have a certain history that cannot be denied, although they've been doing their best to hide it, and they've done a masterful job in hiding our history and teaching us something else that has nothing to do with who we really are, while at the same time pretending to be us, right? What was that?
We are superior. Let's put it plainly.
Well, I don't want to.
It's not to belittle anyone, but it is what it is.
Yes, but it's not a matter about being superior. It's a matter of it's a matter of us coming to our prominence, and
right.
Because currently, even if you want to think that we are, we're not, because look at us. So our behavior is not superior. You can say that, but I do hear what you're saying. We're the eldest. If this was a family, right, which it is, right, the human family, and Allah, God, whatever, the Most High is the father and the mother, right? You got the father and the mother. Well, we are the eldest in the world. Does that make us superior? I guess. They learned everything from us, but we don't have to approach things from that perspective, because it's love, truth, peace, freedom, and justice, right? So I hear you, Brother Coleman. But and yeah, I hear you. I get where you're coming at. We just don't, we seek diplomatic relations. We extend an olive branch, and you cannot seek diplomatic relations or extend an olive branch with while coming with a narrative of superiority. That's not going to work. That's contradictory, and we could be viewed as belligerents, and we want to stay away from that, right? So advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist. So those are racist principles. This is what the United Nations is affirming, the charter. Scientifically false, legally invalid, morally condemnable, and socially unjust. Let me make this, increase the font so we can see it a little better. Okay, so in my studies in the past, it was always said that the United Nations was the devil. They're evil, they're the devil, the Illuminati runs it, the Rothschilds, and all these things. Well, what I'm reading doesn't sound like that, does it? Right? This particular treaty, or what is this, a treaty? Right? It's a convention. This contract that states have became a part of does not show any form of evil. So what is it that these people were talking about? Were they trying to keep us away from the United Nations and the information that they're providing, not just the information that they're providing, but the service that they provide? Perhaps, but when you read it, you find something else. That's why the prophet would always say, "Man knows not by being told," which really means not to be in fellowship and to be in scholarship. You have to do your own research and do your own readings to identify the truth in things as it relates to your understanding. Because this doesn't sound evil, demonic, or Rothschild-like to me, right? Reaffirming that indigenous peoples in the exercise of their rights should be free from discrimination of any kind. In the exercise of their rights, what rights are so? For example, what is the rights? What is our rights as AMPAG? We have state rights, not just AMPAG, but anymore that established their state. We have state rights under just coaches, right? And so we should be free from discrimination of any kind, right? Concerned that indigenous peoples have suffered from historic injustices, right? Concerned that indigenous peoples, let me rephrase that, concerned that Moors have suffered from historic injustices as a result of, inter alia, their colonization and disposition of their lands, territories, and resources. Who are they talking to? Thus preventing them from exercising, in particular, their right to development in accordance with their own needs and interests. Who are they talking to? Recognizing the urgent need to respect and promote the inherent rights of indigenous peoples, i.e. Moors, which derive from their political, talking about states, politics, nationhood, statehood, economic and social structures, and form their cultures, spiritual traditions, histories, and philosophies, especially their rights to their lands, territories, and resources. Who are they talking about? I guess the problem is that they're not coming out directly and saying, "Hey, you Moors, this is for you to read." They're not doing that. But I mean, if you read it and you understand your history, this is why the prophet was so monumental, because without him showing up to bring us out of darkness into the marvelous light, we wouldn't even be able to put the two and two together to determine that we are the indigenous peoples that this document is talking about. They've been trying to wake us up and extend assistance since 2007. Recognizing also the urgent need to respect and promote the rights of indigenous peoples affirmed in treaties, agreements, and other constructive arrangements with states, not individuals, not temples, not organizations, not websites, not clubs, no associations, but states. Welcoming the fact that indigenous peoples are organizing themselves. What is AMPAG, New Mecca, and AMPAC doing? We are organizing ourselves, building a nation. And what is a nation? An organized dual society. Black's Law Dictionary. Black's Law Dictionary. What's hold on a second. Which one is it? Well, all of them. Which Black's Law Dictionary is this? 4th edition. There we go. I had to go grab my Black's Law 4th edition. You see these tabs? Yes, I've been through them. Got some words here for y'all. Okay. States. Welcoming the fact that indigenous peoples are organizing themselves for political, economic, social, and cultural enhancement, and in order to bring to an end all forms of discrimination and oppression wherever they occur. Where is that taking place currently? In Morocco. And so it is our job to bring to an end, a speedy end, all forms of discrimination and oppression wherever it occurs. And so therefore, who is waiting on us? The world. The world is waiting on us. The world needs us, Moors. We must wake up to the fact that we need state governments in order to uplift fallen humanity. We cannot do it as individuals. And the thing that's interesting is that we can put together gangs. We've got gangs. We've got a lot of gangs. Well, a gang is similar to a state, right? Excuse me, it's a structured system. You know, there's a hierarchy, there's a structure there. So how about we switch up our steps from gang banging to statehood, right? We have the capabilities. That is called going back into the minds of our ancient foremothers and forefathers, because that's what we did. We governed society. We built societies. We built civilizations. And you don't build civilizations or govern them without a government. Otherwise, you would just have absolute chaos. Convinced that control by indigenous peoples over developments affecting them and their lands, territories. You see how, hold on a second. How many times did they say that? Let's go back. Our lands, territories, resources, lands, territories, resources, lands, territories, resources. They said it several times. I done lost all of them now. Well, how many times did they say that? Does anyone see it? Where are the rest of them at? Okay. Exercise in particular right of development in accordance with their own. They said lands, territory, and resource. Okay, there goes one. Their lands, territories, and resources. That's one. How many times did they say it? I think, if I recall correctly, they said it 3 times so far, and we haven't gotten any. Here it goes again. So they said it. They mentioned that 3 times. 3 times, recognizing that respect for indigenous knowledge, okay, there it is, convinced that control by indigenous peoples over development affecting them and their lands, territories, and resources will enable them to maintain and strengthen their institutions, cultures, and traditions, and to promote their development in accordance with their aspirations and needs. Recognizing that respect for indigenous knowledge, Moorish science, right? Indigenous knowledge means Moorish science. Recognizing that respect for Moorish science, cultures, and traditional practices contributes to sustainable and equitable development and proper management of the environment, emphasizing the contribution of the demilitarization of the lands. I had to let that sink in a little bit. Emphasizing the contribution of the demilitarization of the lands and territories, here we go saying that again, of indigenous peoples to peace, economic and social progress and development, understanding and friendly relations among nations and peoples of the world. Friendly relations amongst nations and peoples of the world. Recognizing in particular the right of indigenous families and communities to retain shared responsibility for the upbringing, training, education, and well-being of their children, consistent with the rights of the child. Isn't that uplifting fallen humanity? Considering that the rights affirmed in treaties, agreements, and other constructive agreements between states, with a capital S, by the way, and indigenous peoples are in some situations matters of international concern, interest, responsibility, and character. Considering also that treaties, agreements, and other constructive arrangements and the relationship they represent are the basis for a strengthened partnership between indigenous peoples and states. We need a state. We need states. You're not going to get around that. The temple is not sufficient. The temple is one side of the movement. The other side, or the other half of the movement, which is the other half that wasn't told, is statehood, international law, treaties, conventions, constructive arrangements, etc., deals with the other half that wasn't told, Moors. And so in order to identify the other half that wasn't told, we were supposed to do what? Who can answer that question? What were we supposed to do in order to identify the other half that wasn't told? Can someone answer that? I know the Grand Sheik can.
We were supposed to organize and form a state.
Yes, but something that the prophet told us to do. It's the only way that we would have been able to identify the other half that wasn't told. It was to study, study, study. And if you had studied well enough and you came back and asked me what else to study, I would tell you to study yourself. That means in the mirror, you look in the mirror and say, did I study enough? That's what Jay Bay said one time. It was funny. But we were supposed to study, 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 not remain stagnant. He said, don't worship me, study and carry on my laws. That means don't stay stagnant. It's called being active. Moors that think they're being active are actually being passive, because they're stagnating their studies. It's stagnated based on the old narrative, or should I say, temple paradigm, and enforce a constitution paradigm, but they're not taking it any further. If Moors have the ability and are so competent enough, competent meaning mental capacity. If we're so competent enough to master their laws, then we can also raise our degrees and be competent enough to master our laws. What is our laws? Treaties, because treaties are an international law, is based in Moroccan law. It's been said in the ICJ. Acknowledging that the Charter of the United Nations, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights, as well as the Vienna Declaration and Program of Action, affirm the fundamental importance of the right to self-determination of all peoples. We have the right to self-determination, which means you also have the right to remain a ipso jure Moorish subject. Or you may choose between the entire submission of the laws of the empire. We have our right to self-determination. Us in AMPAG, the nationals in AMPAG, the nationals in AMPAC, the nationals in New Mecca, we based on our self-determination, we chose between the entire submission of the laws of the empire and come out of the statelessness known as ipso jure Moorish subject. Okay, affirm the fundamental importance of the right to self-determination of all peoples, by virtue of which they freely determine their political status. There we go. You have the freedom to choose your political status, but know what you're doing. Don't think that because you got a nationality card from RB Bay Publication or from the temple that you're suddenly now a national. That doesn't. You're still a subject. Why? Because you haven't consented to an actual state government or established an actual state government, which has a constitution that has been ratified, promulgated, and deposited, as well as a seat to the treaties, in order to gain your full powers to operate as such. By virtue of which they freely determine their political status and freely pursue their economic, social, and cultural developments. Bearing in mind that nothing in this declaration may be used to deny any peoples their right to self-determination, exercise in conformity with international law. Bearing in mind that nothing, that includes the United States, y'all, nothing in this declaration may be used to, well, I said that wrong. It's not the United States, but bearing in mind that nothing in this declaration may be used to deny any people. So there's nothing in the declaration that can be used to deny us from our right to self-determination exercised in conformity with international law. So in other words, enforcing their constitution is not an exercise that's in conformity with international law. That is in conformity with municipal law, right? With United States laws, not international law. So which route do you want to take? Do you want to operate based on the conformities of dealing with international law, or the conformities of dealing with their municipal laws? You have the right to self-determination. Take your pick. Convinced that the recognition of the rights of indigenous peoples in this declaration will enhance harmonious and cooperative relations between the state, in all caps, the S in caps, capital S, between the states and indigenous peoples, based on principles of justice, democracy, respect for human rights, non-discrimination, and good faith, encouraging states to comply with and effectively implement all their obligations as they apply to indigenous peoples under international instruments, in particular, those related to human rights, in consultation and cooperation with the peoples concerned. If more, I mean, you know, we've read these documents when they, you know, Tasha Reed put it out there, you know, and I don't know, this stuff, a lot of this stuff clearly went over our heads. In fact, we probably didn't even read the preamble. So we got to read the preamble so we have an understanding of what the document is all about. Emphasizing that the United Nations has an important and continuing role to play in promoting and protecting the rights of indigenous peoples. Let me try that again in case it went over your heads. Emphasizing that the United Nations has an important and continuing role to play in promoting and protecting the rights of Moors. Believing that this declaration is a further important step forward for the recognition, promotion, and protection of the rights and freedoms of indigenous peoples. I mean, how many times they got to say the same thing? I mean, how many times they got to say the same thing? Believing that this declaration is a further important step forward for the recognition, promotion, and protection of the rights and freedoms of indigenous peoples, and in the development of relevant activities of the United Nations system in this field. Recognizing and reaffirming that indigenous individuals are entitled without discrimination to all human rights recognized in international law, and that indigenous peoples possess collective rights which are indispensable for their existence, well-being, and integral development as peoples. I mean, you know, they wrote, you know, I mean, I guess they could be a little bit more clearer, but I mean, they're clear enough. They're obviously talking to us. I mean, you know, recognizing that the situation of indigenous peoples varies from region to region and from country to country, and that the significance of national and regional particularities and various historical and cultural backgrounds should be taken into consideration. Solemnly proclaims the following United Nations Declaration on the Rights of Indigenous Peoples as a standard of achievement to be pursued in a spirit of partnership and mutual respect. So Obama signed this. Article 1, indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and international human rights law. So how do we, I mean, you can't enforce these principles without a state. We cannot enforce it as individuals. We have to enforce it as a state. And if we enforce it as a state government that has been properly established, meaning you have a constitution that has been ratified, promulgated, and deposited, then you can invoke Article 1, which states, again, for the record, indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and international human rights law. Article 2, indigenous peoples and individuals are free and equal to all other peoples See, they try to say that we're not equal, and they try to say that we're not free, right? They say that we are inferior and that we are slaves, subjects, and such citizens. Well, Article 2 says something different. Article 2 says indigenous peoples and individuals are free and equal to all other peoples and individuals and to all other peoples and individuals and have the right to be free from any kind of discrimination in the exercise of their rights, such as our rights to establish governments. They cannot discriminate against us. They cannot discriminate against us, in particular, that based on their indigenous origin or identity. Article 3, indigenous peoples have the right to self-determination. By virtue of that right, they freely determine their political status. So, me as an individual, I choose to be a national. And there's nothing, no state, no foreign entity or country or international organization can do about that, especially when they sign this particular treaty or declaration. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Article 4, indigenous peoples in exercising their right to self-determination have the right to autonomy y'all know by now when I pause for a reason. Because AMPAG is autonomous and sovereign and independent from the United States. And we have that right according to Article 4 of the rights of indigenous people. But we have that right regardless. It's not even, that's just one other article that, that's just another article in yet another international agreement that states the obvious. However, the sultans of Morocco, through the various different treaties, have already established that. This is really just being reaffirmed. This is how you're able to identify the fact that the United Nations is using treaty language based on what the sultans wrote, which means that it's based in Moroccan law. It's not me making it up. I'm reading the reference points. Indigenous peoples, in exercising their right to self-determination, have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. So anyone in AMPAG who's concerned about anything, here you go. You know, we are definitely doing the right things here. And we got a ways to go. But if it takes us 3 years, guess what? 3 years is going to be here anyway. So you might as well stay on the path. Indigenous peoples have the right to maintain and strengthen their distinct political. So we have a right to our distinct political identities, for example, right? So let's see. The United States calls their head of state the president. Well, being the fact that we have a right, our right to exercise our distinct political statuses. Well, in AMPAG and New Mecca, and in AMPAG, the head of state is called the waziralrais, right? We call it waziralrais. You don't call it president. We call it waziralrais or prime minister. That is distinct from the United States. And it's also dealing with our distinct culture because it's based in our ancient government principles and seats. Indigenous peoples have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions, while retaining their right to participate fully, if they so choose, in the political, economic, social, and cultural life of the state. Article 6, now that we got through all that, Article 6, every indigenous individual has the right to a nationality. You know, that's the only article that Moors know, is Article 6. Now this one has I don't know, like 46 articles. We're not going to go through them all. I think we're going to stop at Article 7. Article 7. In number 1, indigenous individuals have the right to life, physical and mental integrity, liberty, and security of person. 2, indigenous peoples have the collective right to live in freedom, peace, and security as distinct peoples and shall not be subjected to any act of genocide. You have something to say, brother? Any act of genocide or any other act of violence, including forcibly removing children of the group to another group. So we've got more to go. There's many other articles. We'll stop at 7 and we'll pick up another time when we it will be on Sunday when we discuss the entire treaty as we do on Sundays. So we'll move on to the UN Charter. Let's move on to the UN Charter. So this is the UN Charter. Repertory of practice of United Nations organs. Charter of the United Nations. We're going to deal with Article 1 and Article 2. Article 1 tells you the purpose. What is the purpose of the United Nations? The purpose of the United Nations are to maintain, can y'all see this? The fonts, I mean, it's on the website. See if I could increase it a little bit. How do I increase the fonts on the website? I don't know. I want you all to be able to read it as well, but I don't want to take time to figure that out. I'm not a computer genius like Hakeem Bey. The purpose of the United Nations are, 1, to maintain international peace and security, and to that end, to take effective collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of aggression or other breaches of the peace, and to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. 2, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen universal peace. It's all about peace from all the scores of wars that took place in the past. It's all about peace, which is what? The third principle, right? What's the first 2 principles? Love and truth, peace, freedom, then justice. So when you talk about love, truth, peace, freedom, and justice, you're really looking at due process of law, mediation, arbitration, adjudication. So before we get to adjudication, which is justice, let's try love first. And then let's try truth. Let's try peace. Let's try freedom. Where it all fails, justice must prevail. All right? 2, to develop friendly relations amongst nations. I already read that. Number 3, to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights, and 4, fundamental freedoms for all without distinction as to race, sex, language, or religion, and to be a center for harmonizing the actions of nations in the attainment of these common ends. To be a center for harmonizing the actions of nations. So the purpose of the United Nations is to be a center for harmonizing the actions of nations in the attainment of these common ends. What common ends? Peace. So they are the go-between. Shit in case consular court doesn't prevail. So if consular court don't prevail, You take it to the United Nations. If the United Nations can't do nothing with you, take it to the ICJ, Article 2.
I got a question.
Yes, I wonder if I got an answer. I'm not sure. Let's get with it, brother. What you got?
So I noticed that in these treaties, they always speak of human rights. So just for the sake of understanding and class, human rights is different from civil rights. How so?
Because human
How
rights,
come they, how come they say human rights instead of civil?
because human rights is dealing with humanity is dealing with human persons, human beings. You can't just be a human because the human is a monster, right? So it's dealing with human. No, it is. You want me to pull it up? Black Star Dictionary.
No, I got it.
So human rights is rights for nationals or recognized individuals who have been recognized by their states, their countries of origin, etc. Civil rights is for NBCs, Negroes, Blacks, and Coloreds, subjects, citizens.
Okay.
That's the difference.
Yeah.
That's
Got a
why,
second.
and so when we were going through the whole civil rights movement thing, you'll find an interview with Malcolm X, some guy, some white guy was interviewing him. And I think that was his last interview, because in that interview, he said that he was going to the United Nations to discuss matters dealing with human rights and not civil rights. So it's all about human rights, because human rights is dealing with humans and people who are recognized as humans, breathing sentient beings, versus civil rights, which is dogs have civil rights, right? You can't just kill a dog. So it's for property, whereas human rights is for individual humans as a whole. Islam? Okay, the organization and its members, in pursuant of the purposes stated in Article 1, shall act in accordance with the following principles. Let's read that again. The organization and its members. So the United States is one of the members. 193 member states, in pursuit of the purposes stated in Article 1, shall act in accordance with the following principles. 1, the organization is based on the principle of the sovereign equality of all its members. 2, all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfill in good faith the obligations assumed by them in accordance with the present charter. 3, all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. 4, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Y'all didn't hear me. Nobody heard me. Therefore, I'm going to read it again. 4, all members, including the United States, shall refrain in their international relations from the threat or use of force against the territorial integrity of AMPAG or political independence of AMPAG, or in any other manner inconsistent with the purposes of the United Nations. Let's try that one more time, because I want the nationals to understand the security that we have as nationals, as opposed. What was that?
Be redundant.
I got to be redundant. I got to be redundant, because this is, I mean, number 4 was, come on, it's just, come on. All members, including the United States, shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. And then finally, 5, all members shall give the United Nations every assistance in any action it takes in accordance with the present charter, and shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement actions. So they can't even, so if the United Nations is dealing with another state for violating a right, then another state can't even intervene and try to assist that other state. Interesting. Okay, so that's just 2 articles from the United Nations Charter, whereas there's 110 articles, I believe. Yep, Article 110. Just for the sake of the class, let's just see what Article 10 says, because Article 10 and 110 and Article 111 are based on the final, chapter. What is that? Chapter 19, right? X1, XIX, that's 19. In Roman numerals. Let's just, for the heck of it, let's just see what they're talking about here. Article 110, the present charter shall be ratified. Instructions. You see this in all the treaties. It got to be ratified. The present charter shall be ratified by the signatory states in accordance with their respective constitutional processes. 2, the ratification shall be deposited with the government of the United States of America. There is no United States of America, so it's got to be deposited with the United States, right? So, keeping in mind that the United Nations is in the United States, which is actually in Morocco, and the United States is in Morocco. United Nations being in Morocco, specifically Manhattan. Okay, but then the United States must notify all the signatory states of each deposit, as well as the Secretary General of the organization when he has been appointed. So you deposit your ratified copy with the United States, and the United States' job is to notify all the signatory states. It's the same thing you find when you deposit, when you sign, and if you were a signatory power with the Act of Algeciras, you were supposed to deposit, ratified, and deposited it where? In Madrid. The Treaty of Madrid, all signatory powers had to ratified and deposited where? In Tangiers. I mean, it's the same thing going on here, yo. We got to keep in mind that international law is based in well-settled principles, and you see well-settled principles when you start seeing consistencies, and you see this is the same language you see on all the treaties, all the conventions, all the declarations. The present charter shall come into force upon the deposit of ratification by the Republic of China, France, the Union of Soviet Socialist Republics, which is Russia, the United Kingdom of Great Britain and Northern Ireland, and the United States of America, and by a majority of the other signatory states. A protocol of the ratifications deposited shall thereupon be drawn up by the government of the United States of America, which shall communicate copies thereof to all the signatory states. In other languages, you would in other treaties you would hear a language where they say that it will be transmitted through diplomatic channels. That's the same thing. So it's being transmitted by ways of diplomatic channels to all the other signatory powers. The states signatory to the present charter, which ratify it after it has come into force, will become original members of the United Nations on the date of the deposit of their respective ratifications. So it's all about ratifying and depositing. So you ratify and deposit your constitution with who? The Secretary General of the United Nations. There's actually in Article 102. Let's go back to Article 102 and look at that real quick once I'm done with 111. Article 111, the present charter of which Chinese, French, Russian, somebody jamming in the background. The present charter of which Chinese, French, Russian, English, and Spanish text are equal. Can you mute yourself, please? Could you please mute yourself? AMPAG, is that who that? No, it's somebody else. The present charter, of which Chinese, French, Russian, English, and Spanish texts are equally authentic, shall remain deposited in the archives of the government of the United States of America. Duly certified copies thereof shall be transmitted by that government to the governments of the other signatory states. There you go, transmitted by, that's really saying transmitted through diplomatic channels. I mean, they all say the same thing. I mean, they're just, all the treaties basically say the same thing, especially as it relates to the instructions of what you must do once it's been completed, or should I say ratified. Let's see what does 102, what 102 is stating. Let's just go to 102 real quick. Miscellaneous. There it is. Article 102. Every treaty and every international agreement entered into by any member of the United Nations after the present charter comes into force shall as soon as possible be registered with the Secretariat and published by it. No party to any such treaty or international agreement which has not been registered in accordance with the provisions of paragraph 1 of this article may invoke that treaty or agreement before any organ of the United Nations. Right? So every treaty and every international agreement that we enter into must be deposited with the Secretary General. That's what we did when we acceded to the treaties that we've acceded to. We deposited with the United Nations. Now we have the right to what? Invoke, where does it say? No party to any such treaty or international agreement which has not been registered in accordance with the provisions of paragraph 1 of this article may invoke that treaty or agreement before any organ of the United Nations. All you got to do is go to Google and pull up United Nations Charter and this would come up. And you have, and it's in chronological order. It's very well organized. You know, you just click and go. You just start reading the stuff here that we need to understand. Membership organs, the General Assembly, the Security Council, Pacific settlement of disputes, actions with respect to threats to the peace, breaches of the peace, and acts of aggression, right? Regional arrangements, etc. Let's move on from there. Let's go and let's talk about this right here. Understanding international law. This is a United Nations document. 2011 treaty event towards universal participation and implementation. So the first question that's being posed has a very simple answer. Understanding international law. What is international law? International law, let me boost this up a little bit, zoom it up. That everybody can read this clearly. What is international law? International law is the law governing relations between states. Anything else? Do I need to elaborate further? What is international law? International law is the law governing relations between states. So we will be utilizing international law to govern our relations between us and the United States. And they're not even a state. They're an international organization. They're de facto. We are de jure, which means we have the ultimate authority. Even if the United States of America was in position, we still have the ultimate authority over the United States of America, right? Because they are the tenants and we are the landlords. What are the benefits of international law? Well, without it, there could be chaos. International law sets up a framework based on states. Let me move this to the side here. As the principal actors in the international legal system, it defines the states' legal responsibilities in their conduct with each other within state boundaries, right? So that's our longitude and latitude. that we that we utilize to identify our dominions and or territory here in the chartered colony formerly known as the state of Georgia. And in their treatment of individuals, international law encompasses many areas, including, listen to this, human rights, disarmament. Disarmament is what? Demilitarization. Did I just read that on the rights of indigenous people? Transnational organized crime, United States. That's an organized crime. Syndicate, the United States, and its several chartered colonies are what I would call, or what the world would know as, an organized crime syndicate, the biggest gang in the world. Refugees, migration, statelessness, right? So Moors are stateless. International law settles that dilemma. The treatment of prisoners, the use of force, the conduct of war, the environment, sustainable development, the oceans, outer space, global communications, and world trade. So you see here, the oceans, water, outer space, air, global, the earth. Let's see where else we see that, and keep that in mind. Keep what I just said in mind. The oceans, which is water, outer space, which is air, global communications, or the word global, the earth, the land. Keep that in mind. With so much conflict in the world, how can this really work? Well, international law does work, at times invisibly and yet successfully. World trade and the global economy depend on international rules, which regulate the activities required to conduct business across borders, uti possidetis juris, including financial institutions, transportation of goods, and the exploitation of natural resources. There are treaties for roads, airspace, and bodies of water. There are treaties for roads, airspace, bodies of water. Go back to the top. It says the oceans, outer space, global. So that's really saying land, air, water. And what does land, air, water signify? LAW, law, Moorish laws. So when you look at our Constitution, in the dominions, it talks about exactly that. From the land to the waters and the air, all the way up to the cosmos. That's in our Constitution, all the way to the cosmos. Okay? And as new needs arise, whether to prevent or punish terrorist acts or to regulate e-commerce, new treaties are being developed. Does international treaty law impinge on a nation's sovereignty? To become party to a treaty, a state must express through a concrete act its willingness to undertake the legal rights and obligations contained in the treaty. It must consent to be bound by the treaty. Okay, well, how does a state express its consent to be bound? Okay. Answer: a state can express its consent to be bound by a treaty in several ways, as specifically set out in the final clauses of the relevant treaty. The most common ways are definitive signature, ratification, acceptance, approval, and accession. The most common ways are definitive signature, ratification, acceptance, approval, and accession. The terms ratification, acceptance, and approval all mean the same thing in international law, particularly when used following signature subject to. The state has agreed to become party and is willing to undertake the legal rights and obligations contained in the treaty upon its entry into force. The state has agreed to become party and is willing to undertake the legal rights and obligations contained in the treaty upon its entry to force. So every treaty that the United States have signed on to, they have been willing to undertake the legal rights and obligations contained in that treaty. So when we accede to the treaties that the United States are signatory powers to, guess what? The United States had agreed to become party and is willing to undertake the legal rights and obligations contained in the treaty. So therefore, we can hold them accountable when they think they can just breach one of these provisions. You see? I'm sorry, y'all. This damn internet shit sucks. Man, my internet sucks. I'm sorry. Okay, let's go back. All right, so the United States has agreed to these. So therefore, this is how we can. I lost my train of thought. My internet keeps kicking out, y'all. I'm sorry. They can't seem to do anything about it. I don't know what I will do in terms of this situation. Maybe good brother Hakeem can come through and do a diagnosis for me, because the people they send in, they ain't worth a damn. All right, the state has agreed to become party and is willing to undertake the legal rights and obligations contained in the treaty upon its entry into force. So the United States, we can hold them accountable for many things, as long as we have acceded to the treaties, and are part of the signatory, as one of the signatory powers. Why don't you go small here? I don't know. How do I make this? Let's see. Hold on one second, you all. Let me. Well, that's not what I'm trying to do. I'm trying to minimize this. Okay, whatever. Signing a treaty is one of the most common steps in the process of becoming party to a treaty. However, simply signing a treaty does not usually make a state a party, although in some cases, hold on. Oh, wait, I'm not sharing my screen. That's what it is. My screen ain't being shared. Let me go back to sharing the screen. I'm sorry. What was that? Okay, right here. There we go. Okay, we're back. Okay, signing a treaty is one of the most common steps in the process of becoming a party to a treaty. However, simply signing a treaty does not usually make a state a party, although in some cases called definitive signature, it might. A state does not take on any positive legal obligations under the treaty upon signature. Signing a treaty does, however, indicate the state's intention to take steps to express its consent to be bound, right, by the treaty at a later date. Signature also creates an obligation on a state in the period between signature and ratification, acceptance, or approval to refrain in good faith from acts that would defeat the object and purpose of the treaty. This is why we understand and we know that we're in a good place here with what we're doing. We can't be in fear. We gotta have confidence. And the only way you would establish your confidence in what it is that we're doing here in this state is by studying, reading these documents. Make yourself approve. Make the information yours. Man knows not by being told. Multilateral treaties contain terms that indicate where the treaty is to be available physically or signing and for what period of time. Multilateral treaties often provide that they will be open for signature only until a specified date, after which signature will no longer be possible. Once a treaty is closed for signature, a state generally may become a party to it by means of accession. So let's see. The Act of Algeciras. It was not open for signature. That took place in 1906. It's been enforced for what, over 100 years? Yet we are parties to the Act of Algeciras. Why? Because once a treaty is closed for signature, a state generally may become a party to it by means of accession. We acceded to the treaties. We know what we're doing, and we're doing the right things. It's right here. The divine instructions. Some multilateral treaties are open for signature indefinitely. Most multilateral treaties on human rights issues fall into this category, such as the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, the International Covenant on Civil and Political Rights, 1966, and the International Convention on the Elimination of All Forms of Racial Discrimination, 1966. Good brother Hajib Amaru, are you there, good brother? Brother Amaru. If you don't, if you're there, but you're not hearing me, I mean, you hear me, I'm not sure, but the reason why I'm calling on you, brother, is because we want to accede to these treaties as well. What are those treaties? The Convention on the Elimination of All Forms of Discrimination Against Women from 1979, the International Covenant on Civil and Political Rights, 1966, and the International Convention on the Elimination of All Forms of Racial Discrimination of 1966. We will accede to those treaties and become signatories, or actually these are one of the treaties that you could actually just sign on to. Because why? It's open for signature indefinitely. How are treaties enforced? Let's find that out. There is no overarching compulsory judicial system or coercive penal system to address breaches of the provisions set out in the treaties or to settle disputes. That is not to say that there are no tribunals in the international legal system. For example, the Charter of the United Nations established the International Court of Justice, the principal judicial organ of the United Nations, as a means by which member states may settle their disputes peacefully in accordance with international law. The court can also give advisory opinions on legal questions referred to it by duly authorized international organs and agencies. United States. Member states of the United Nations, in cases to which they are parties, are obliged to abide by the court's decisions. However, before a case can go before the court, a state must have accepted the jurisdiction of the court, either in general or in relations to a specific case. A state that has not accepted the court's jurisdiction cannot be forced to appear before the International Court of Justice. Right? So you have to have accepted the court's jurisdiction, which we have by acceding to the ICJ statutes. So we have accepted the court's jurisdiction. AMPAG has, so has New Mecca, and so has AMPAG. States may also entrust the settlement of specific disagreements to other international dispute resolution mechanisms established by treaties such as the International Tribunal for the Law of the Sea, the Permanent Court of Arbitration, and the dispute settlement bodies of the World Trade Organization, among others. Different treaties may also create different treaty body regimes to encourage the parties to abide by their obligations and undertake actions required for compliance. For instance, the Human Rights Committee monitors the implementation of the International Covenant on Civil and Political Rights. The Committee on the Elimination of Racial Discrimination monitors implementation of the International Convention on the Elimination of All Forms of Racial Discrimination. I mean, they're just, They're just repeating themselves. I went over so far 3 different documents, and they're all saying basically the same things, you know? The elimination of racial discrimination monitors implementation of the International Convention on the Elimination of All Forms of Racial Discrimination, and the committee against torture monitors implementation of the Convention Against Torture and other cruel, inhuman, or degrading treatment. The Security Council can also adopt, under Chapter 7, measures to enforce its decisions regarding threats to international peace and security, breaches of the peace or acts of aggression. Such measures may include sanctions or authorizing the use of force. You see, it's all about peace. Peace, peace, peace. This is all they continuously keep talking about. And that's the end of that particular document. Any questions on this document? There goes their seal, United Nations. Any questions on this document before we move on to the final document? And then after that, we'll have a Q&A. I guess this will be a short one. If there's no questions, I'll move on to the final document, which is right here, the ICJ. Who is the ICJ? What are they about? The court. The International Court of Justice is the principal judicial organ of the United Nations. It was established in June 1945 by the Charter of the United Nations and began work in April 1946. The seat of the court is at the Peace Palace in The Hague, Netherlands. Of the 6 principal organs of the United Nations, it is the only one not located in New York, United States of America. So all the other organs are located in Morocco. The court's role is to settle, in accordance with international law, legal disputes submitted to it by states, not individuals, by states, and to give advisory opinions on legal questions referred to it by authorized United Nations organs and specialized agencies. The court is composed of 15 judges who are elected, not self-appointed, who are elected for terms of office of 9 years by the United Nations General Assembly and the Security Council. It is assisted by a registry, its administrative organ. Its official languages are English and French. And that's it. That's why a lot of documents you'll find in English and French, like the Treaty of Peace and like the Treaty of Madrid. Can you guys see this International Court of Justice website that I have that I'm sharing? Can you guys see that?
No.
Why not? Okay, let me stop sharing. Share again. So I'm reading that and I'm thinking y'all can see it. Can you see it now?
Yes, we see it now.
Okay, great. Thank you. Keep me on point, y'all. Okay, so let's go into the history. That's why I have my phone open so I can kind of like keep track on what's going on through my phone. All right, so what's the history? The creation of the court represented the culmination of a long process of developing methods for the pacific settlement of international disputes, the origins of which can be traced back to classical times. Article 33 of the United Nations Charter lists the following methods for the specific settlement of disputes between states: negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resort to regional agencies or arrangements, to which should also be added good offices. Some of these methods involve the services of third parties. For example, mediation places the parties to a dispute in a position in which they can themselves resolve their disputes thanks to the intervention of a third party. Arbitration goes further in the sense that the dispute is submitted to the decision. The dispute is submitted to the decision or award of an impartial third party so that a binding settlement can be achieved. The same is true for judicial settlement. Judicial settlement meaning adjudication, the method applied by the International Court of Justice. See, so the judicial settlement is applied by the International Court of Justice, except that a court is subject to stricter rules than an arbitral tribunal, particularly in procedural matters. So it went over due process and the process that's involved in due process. I'll say it again. It says, for example, mediation. Well, let me go back. It's called negotiation, inquiry, mediation, conciliation, arbitration, and then if none of those other methods serve its purpose or does not work, then the final step will be judicial settlement. Okay. Historically, mediation and arbitration preceded judicial settlement. The former was known in ancient India. Well, whenever you see the word ancient, who are you dealing with? As it relates to ancient India, or what they call that one, y'all? Hikupta? No. I keep getting that one mixed up. What was India's original name?
Hindustan.
Hindustan. With the Mauryan dynasty. They know about the Mauryan dynasty. They know about the Mauryan dynasty today. I had an Indian friend of mine that told me, you know, and going, you know, in their high schools down there, they talk about the Mauryan dynasty. Of course, they're whitewashed, but you cannot spell Mauryan dynasty or Mauryan without the word Moor. Just saying. The former was known in ancient India and the Islamic world, synonymous cultures. Whilst numerous examples of the latter can be found in ancient Greece, here we go again, in China, among the Arabian tribes, in maritime customary law, in medieval Europe, and in papal practice. The origins of arbitration. What's the origins of arbitration? The modern history of international arbitration is generally recognized as dating from the so-called Jay Treaty of 1794 between the United States of America and Great Britain. This treaty of amity, commerce, and navigation provided for the creation of 3 mixed commissions composed of equal numbers of American and British nationals. You see, American and British nationals ain't got nothing to do with Moors, although the British nationals are probably Moors. The brutish, that's what they call them, the brutish, right? King George III, brother had an afro. Whose task it would be to settle a number of outstanding questions between the 2 countries, which it had not been possible to resolve by negotiation. While it is true that these mixed commissions were not strictly speaking organs of third-party adjudication, they were intended to function to some extent as tribunals. They reawakened interest in the process of arbitration. Throughout the 19th century, the United States and the United Kingdom had recourse to them, as did other states in Europe and the Americas. The Alabama claims arbitration in 1872 between the United Kingdom and the United States marked the start of a second, even more decisive phase under the Treaty of Washington of 1871. Very interesting. I've never heard of any of these treaties. You know, and so that's why you read these documents and you go through these study materials, because it gives you further reference points, right? Under the Treaty of Washington of 1871, the United States and the United Kingdom agreed to submit to arbitration claims by the former for alleged breaches of neutrality by the latter during the American Civil War. The two countries set forth certain rules governing the duties of neutral governments that were to be applied by the tribunal, which they agreed should consist of 5 members to be appointed by the heads of state of the United States, the United Kingdom, Brazil, Italy, and Switzerland, the last 3 states not being parties to the case. The arbitral tribunals ordered the United Kingdom to pay compensation, which it duly did. The proceedings served to demonstrate the effectiveness of arbitration in settling of a major dispute and led during the latter years of the 19th century to a range of developments, namely a sharp growth in the practice of inserting in treaties clauses providing for recourse to arbitration in the event of a dispute between the parties. And so understanding these principles is why we don't want to come off as belligerents. We want to come off as if we're, seeking diplomatic relations. And there is no, if they don't accept the diplomatic relations, then we just take them through the due process, mediation, arbitration, and if it doesn't work, consular court. And if consular court doesn't prevail, ICJ, right, for the final adjudication in the case or the matter or the dispute. Point 2, the conclusion of general treaties of arbitration for the settlement of specified classes of interstate disputes. Point 3, efforts to construct a general law of arbitration so that countries wishing to have recourse to this means of settling disputes would not be obliged to agree each time on the procedure to be adopted, the composition of the tribunal, the rules to be followed, and the factors to be taken into consideration in making the award. And finally, proposals for the creation of a permanent international arbitral tribunal to avoid the need to set up a special ad hoc tribunal to decide each individual dispute. So that's the basic rundown on the history. The Hague Peace Conference and the Permanent Court of Arbitration, right? Then you also have the Permanent Court of International Justice. Then you also have the International Court of, then you can talk about, okay, let's go through this one. Let's see what the first paragraph is saying. The outbreak of war in September 1939 inevitably had serious consequences for the PCIJ, which had for some years been experiencing a decline in its level of activity after its last public sitting on 4 December 1939 and its last order on 26 February 1940, the Permanent Court of International Justice, in fact, dealt with no further judicial business and no elections or judges were held. In 1940, the court relocated to Geneva, leaving one judge in The Hague together with a few registry officials of Dutch nationality. Despite the war, consideration needed to be given to the future of the court and to the creation of a new international political order. In 1942, the United States Secretary of State and the Foreign Secretary of the United Nations declared themselves in favor of the establishment or reestablishment of an international court after the war. So this is the history. And the Inter-American Judicial Committee recommended that PCIJ's jurisdiction should be extended. Early in 1943, the United Kingdom government took the initiative of inviting a number of experts to London to constitute an informal inter-allied committee to examine the matter. That committee, under the chairmanship of Sir William Malkin, United Kingdom, held 19 meetings, which were attended by jurists from 11 countries. In its report, which was published on 10 February 1944, it recommended that the statute of any new international court should be based on that of the Permanent Court of International Justice, that the new court should retain an advisory jurisdiction, that acceptance of the jurisdiction of the new court should not be compulsory, and that the court should have no jurisdiction to deal with essentially political matters. Meanwhile, on October 1943, following the conference, China, the USSR, the United Kingdom, and the United States issued a joint declaration recognizing, like, you know, they're just, see, the United States is in Morocco, under the jurisdiction of Morocco. However, the Moxons in Morocco are asleep. And so by default, here you got the United States just running the world. They just part of everything, right? This is exactly what's going to happen when we come back into power. We're going to be the ones determining, establishing, and erecting several different processes and institutions in international law for the upliftment of fallen humanity, and operate it as such under love, truth, peace, freedom, and justice, as opposed to these actors, right? Yeah, I got off track because I'm like, damn, I keep reading the United States, you know, they're just all involved in everything. Well, they're taking our place. So it's time for us to take back our rightful place in the affairs of men, so that we may be the ones to control the destiny of the world under love, truth, peace, freedom, and justice. Okay. The United Kingdom and the United States issued a joint declaration recognizing the necessity of establishing at the earliest practicable date a general international organization based on the principle of the sovereign equality of all peace-loving states and open to membership by all such states, large and small, for the maintenance of international peace and security. So you guys are actually so-called interested in peace and security, however, you don't operate as such. So it seems to be a contradiction, but it is what it is, because the establishment of the International Court of Justice is based especially on that, and considering that it's coming off of the Charter of the United Nations. So we'll stop there. Here's on this right-hand column, you've got the members of the court, current members, all members, presidency, statements of the president, chambers and committees, judges, how the court works, you know. Let's see something. The court may entertain two types of cases: legal disputes between states submitted to it by them, contentious cases, and requests for advisory opinions on legal questions referred to it by United Nations organs and specialized agencies, advisory proceedings. So those are the two different forms of cases they take part in. What is a contentious case? Only states members of the United Nations and other states which have become parties to the statute of the court, or which have accepted its jurisdiction under certain conditions, may be parties to contentious cases. The court is competent to entertain a dispute only if the states concerned have accepted its jurisdiction in one or more of the following ways. I said I was going to move on, but let's just go through this real quick, because I got one more thing I want to discuss, and then we'll go into Q&A or whatever. By entering into a special agreement to submit the dispute to the court by virtue of a jurisdictional clause, i.e. typically when they are parties to a treaty containing a provision whereby, in the event of a dispute of a given type or disagreement over the interpretation or application of the treaty, one of them may refer the dispute to the court. And then the third contention, or not contention, but the third point, through the reciprocal effect of declarations made by them under the statutes, whereby each has accepted the jurisdiction of the court as compulsory in the event of a dispute with another state having made a similar declaration. A number of these declarations, which must be deposited with the United Nations Secretary General, contain reservations, including certain categories of disputes. So you have to, so even the dispute has to be deposited, right, with the United Nations Secretary General. States have no permanent representatives accredited to the court. Right, that's another good point. States have no permanent representatives accredited to the court. They normally communicate with the registrar through their Minister of Foreign Affairs. Right, so the states communicate with the registrar through the Minister of Foreign Affairs or their ambassadors accredited to the Netherlands. When they are parties to a case before the court, they are represented by an agent. An agent plays the same role and has the same rights and obligations as a solicitor or a voie, A-V-O-U-E with the accent point above the E, in a national court. However, since international relations are at stake, the agent is also, as it were, the head of a special diplomatic mission with powers to commit a sovereign state. She receives communications from the registrar concerning the case and forwards all correspondence and pleadings duly signed or certified to him. In public hearings, the agent opens the argument on behalf of the government. When you go and you look at the any of the cases, but the case with France versus the United States, that's exactly what you see. It's the agents who open up the argument, right? In general, whenever a formal act is to be done by the government represented, it is done by the agent. Agents are sometimes assisted by co-agents, deputy agents, or assistant agents, and always have counsel or advocates whose work they coordinate to assist them in the preparation of the pleadings and the delivery of oral argument. Since there is no special international court of justice bar, there's no bar, there are no conditions that have to be fulfilled by counsel or advocates to enjoy the right of pleading before it. The only exception being that they must have been appointed by a government to do so. You have to be appointed by the government, right? You have to be appointed by the government. It's all about states. All right, I'll leave that one there. You guys can go back and look through the International Court of Justice website to gain further understanding of their processes and how they work. And to conclude, let me go to, where is it? Preemptory norms. Preemptory norms. Let's discuss preemptory norms real quick before we close out. Okay. A preemptory norm, also called jus cogens or ius cogens, ius, right? I-U-S, is Latin for compelling law. So jus cogens means compelling law. Is a fundamental principle of international law that is accepted by the international community of states as a norm from which no derogation is permitted. There is no universal agreement regarding precisely which norms are jus cogens, nor how a norm reaches that status. But it is generally accepted that jus cogens bans genocide, maritime piracy, and slaving in general, i.e. slavery as well as slave trade, i.e. human rights, wars of aggression and territorial aggrandizement, torture, and refoulement. The latter two are involving and controversial as they rest mainly on the definition of torture in regards to criminal sentencing. If sentencing is not cruel, inhumane, or degrading, but arbitrary or disproportionate, convictions are imposed, then a state's refoulement. We're limited to the returning of unsustainable asylum claimants may still be lawfully conducted to many such countries which are judicially developing, such as those lacking a clear separation of powers, with a relatively heightened risk of political persecution and reports of unfair trials. All right. Status of preemptory norm under international law. Unlike ordinary customary laws, which has traditionally required consent and allows the alteration of its obligations between states through treaties, preemptory norms may not be violated by any state through international treaties or local or special customs or even generally customary rules not endowed with the same normative force. Discussions of the necessity of such norms could be traced back as far as 1758, the Law of Nations. In 1764, Jus Gentium, clearly rooted in principles of natural law, but it was the judgment of the paramount court of international justice that indicate the existence, sorry, I lost my position, the existence of such a preemptory norm. In the SS Wimbledon case in 1923, not mentioning preemptory norms explicitly, but stating how state sovereignty is not inalienable. Under Article 53, this is where I wanted to go. This is where I was really wanting to go. Under Article 53 of the Vienna Convention on the Laws of Treaty, any treaty that conflicts with a preemptory norm is void. The treaty allows for the emergence of new preemptory norms, but does not specify any preemptory norms. It does mention the prohibition on the threat of use of force and on the use of coercion to conclude an agreement. A treaty is void if, at the time of its conclusion, it conflicts with a preemptory norm of general international law. For the purposes of the present convention, a preemptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. So that right there is the reason why the secret Treaty of Verona is null and void ab initio, because it was done in secret. You know, that's and which is also the purpose why you must deposit your treaties with the United Nations. This is aggravating, y'all. I guess the only other option is to switch up. Maybe I need to go back to Xfinity. So anyhow, you guys, okay, I was talking about the just cogents. What I was reading was the Article 53 of the Vienna Convention, in which it states that you cannot violate preemptory norms, and there can't be no derogation in dealing with preemptory norms and just cogents. You just can't violate it. You can't go against it. That's according to law. And that's the reason why the treaty of the secret Treaty of Verona is null and void ab initio, because it wasn't deposited for the record with the United Nations or any other government or any other international organization for that matter, which makes it private law, right? So the secret Treaty of Verona is based in private law, and private law is repugnant to international law. International law is public law, allowing all other nations and all other peoples to examine the provisions in it, right? Public law is supposed to be for all peoples, or really law is supposed to be for all peoples. But I mean, there is a place, a time and place for private law. We have private law within our state. What's that private law? The National Trust. The National Trust is our private law, but our legislation is our public law. You see, so our public law is for all to see, all to bear witness to, but our national trust is a different type. Is our internal. Is the law that's governing the protection of our nation, of our nationals, as we bring our properties into the national trust. So your national trust is your private law. Your legislation and such is your public law, right? So international law in general is public. And so for you to have a treaty or any form of agreement that's secret and has not been put on the record for all to witness, it falls under private law, which is repugnant to international law. And so therefore it becomes void ab initio in international law, which means it cannot be, you cannot, what that really means is that you can't take anyone to court, to the ICJ, based on disputes dealing with a secret treaty. So the secret treaty of Verona is null and void. We don't need to even necessarily worry about it. It has no judicial standing because it absolutely violates international law, but more specifically, it violates just cogence. It violates human rights because it's going against the human rights of the Moors. You see, which is why they didn't deposit it, so that no one knows. It's a secret, the hidden hand, right? The hand inside the breast coat, whereas the prophet came with the hand outside the breast coat. He unveiled all the secrets. That's what public law is. With that said, brothers and sisters, mothers and sons, I yield the floor for any questions, comments, concerns, criticisms. I got some good light today. You can see me a little bit better. Shoot, I'm listening.
Islam, this brother Salomo.
I know it
it's
is.
More like, this is a comment.
Mhm.
It's in alignment with the Vienna Convention of 1969, which is the law of treaties.
Yes.
If we go to Article 1 states that it's treaties between states. And
That's correct.
that is to be emphasized because from that point on, which was 1969, that point on, all of the conventions are dealing with only states. So it can't be an individual in the state or organization in the state. It has to be between states.
That's correct. And that's that's the reason why that's the reason why the United States. It's my position. Okay. That's the reason why the United States is they're not signatory powers to the Vienna Convention anyway. But they are signatory powers to other treaties though.
Right.
But that was a great comment and observation there, good brother Solomon.
Yeah, and then another thing too, one of the brothers asked a question about civil rights and human rights. And I just wanted to add that human rights is actually something that's enforced by the United Nations, and they have policies in place to protect human rights, whereas civil rights is a domestic privilege type thing where it is not protected by the United Nations. And one of the deals with the states and the United Nations, one sovereign state cannot interfere with the actions of another sovereign state. So if individuals are ipso jure Moorish subjects or citizens, and they are submitting to the authority of another sovereign power, the United Nations cannot step in and enforce human rights violations. So
that's why, exactly, and that's why they haven't stepped in to help us. For one, we're not even in our proper status as nationals. We need governments in order for them to be able to step in to assist, which we would have to petition them through consular court for their assistance or their I guess you could say assistance, in, for lack of a better term. I forgot the correct term. It's an international law term. But yes, that's yes, good brother. That's a wonderful point you just made there.
Islam.
Anyone else? I'm all ears. All right, well, not much else to say, I guess, huh? Well, we'll close out. It's right on time at 10 o'clock. There's only 3 more minutes left before 10 o'clock hits. we'll do on Sunday we will complete the act of Algeciras. I'm sorry I wasn't able to do it last Sunday, but we'll do it this Sunday for sure. Well, I cannot say for sure because there's never no telling what's gonna happen, but we're definitely gonna go in that direction. Hopefully we can complete it on Sunday. The act of Algeciras, we got chapters 6 and 7. And I got some other documents we'll be discussing along with the completion of that particular treaty. And then also we'll have a meeting. We'll discuss the meeting. We got to figure it out. I'll put in the chat, in the Telegram chat, a vote for the best day for us to have our next meeting, so that we can go over the whatever progress that we've made thus far with the national trust, the nationality paperwork, etc. Okay, so with that said, good brothers and sisters, mothers and sons, Islam, may you all have a wonderful night.
Islam.
Peace and love.
Islam. Peace and love.
Peace.